Welcome to another edition of Question and Answer with a Criminal Defense Attorney. I'm Mark Solomon, a defense attorney in Denver, Colorado, and today's question is about continuances. But before we get to that, don't forget to click like if you're enjoying this video, and if you're enjoying all these videos, don't forget to click subscribe with a little bell next to it to be notified of future videos. So, continuances. What is a continuance? The answer is when you go to court, you make an appearance, and you need more time. Anytime you're not resolving the case or whatever the appearance is scheduled for, you're asking to delay that for some reason or another. So, like for example, if you go to an arraignment and you need another arraignment because the parties aren't ready to proceed for whatever reason, you ask the court for a continuance or to continue the arraignment. Now, you can do these types of things in general on paper beforehand with a motion to continue. And if it's a jury trial you're continuing, it should be in a written pleading as opposed to just showing up on the day of trial and saying, "I'm sorry, Judge, I need to continue the case." If you do a motion to continue, potentially you might not need to appear. Now, because of bond issues, and I'll put a link right up here somewhere about bond, and if the defendant is on bond, then they must appear for every scheduled court appearance, even if it's continued. So, in today's world of COVID-19, we're doing a lot of appearances by video, so that shouldn't be a problem. But if a court case is continued and the judge is not allowing a WebEx appearance or some other sort of video appearance or phone or something like that, then the defendant must appear. And if the attorney, for whatever reason, can't be there, then the defendant shows up, signs for the next court date, and leaves, just to prove that they are compliant with the terms of their bond, one of which is showing up for all court appearances. Okay. So looking at just a list of some of the reasons why I could possibly imagine to continue, you show up for a pretrial conference, you show up for an arraignment in district court, and you need more time. A lot of times you're asking for more time for plea negotiation because there's pending discovery. You haven't received everything you have. I've got a case right now where we're waiting on DNA results. But sometimes we're just trying to build mitigation, meaning I'm trying to get together the information to make the district attorney see the case in a different way, something that might make the plea offer better. VRA, here, I'll try to put another link up here in the corner. But VRA is something to where if the prosecutors have not consulted with the victim in a case and they need to, they can't extend an offer until they do that. So sometimes if it's a bond modification or a plea offer or a disposition hearing, the district attorneys are going to need to continue the case for victims' rights to make sure that their victims' rights compliant. Or I've listed here number 5, other good cause. There's a million reasons you could continue a case, but it has to be a good reason. Okay, so that is the question and answer for today. If you would like your own question answered in a future video, don't forget, you can put it in the comments below, email it to me, or tag me on Twitter. And as always, if you are being questioned by the police and they ask you where you've been, what you've done, what you have, or what you know, you always have a reason to say, you always have a right to say, "I don't want to talk to you, and if they persist, I want an attorney."